Welcome to Thursday night. Hey, all, John Skiba here on another Thursday night here on the Consumer Warrior YouTube channel. If this is your first time here, my name is John Skiba. I am a bankruptcy and consumer protection attorney in the state of Arizona. I help people who are dealing with serious debt problems, debt collection lawsuits. I help defend people who are in that, all those types of things. And each and every week we come on the channel here to do a live Q&A to go over questions that you might have, share some insights, tips, strategies, all that kind of stuff. I am a licensed attorney in the state of Arizona. I'm not licensed anywhere else. And you shouldn't consider this legal advice. This doesn't create any type of attorney-client relationship or anything like that. These are all the disclaimers that lawyers give, even though I think that's probably apparent to most people. I tell everybody every week, this is some guy talking on YouTube. If you need real legal advice, I highly recommend you contact an attorney in your state. If you're in the state of Arizona, my information will be below and you can reach out, and I do consultations. I do have consultations that you can set up there. So the way we do this is if you have a question, go ahead and put it in the comment section on YouTube. I'll put it up here on the screen and we'll discuss and give you some different insights into what might be helpful. So one thing I like to do each and every week is grab some comments from the YouTube channel and go over those that I think could be applicable to a lot of people. One of the first ones I got is relating to debt collection lawsuits. This person said, can a debt collector sue me again if I get the case dismissed? This is a good question because it seems like, if you get the case dismissed, that means you win and the case is over. And then you turn around 6 months, a year later, and they've actually filed a lawsuit against you. It all depends on how the case gets dismissed. There are multiple ways a case can get dismissed. Some of the common ones where they can refile the lawsuit against you. If, let's say that they file a lawsuit and like here in Arizona, they file a lawsuit and then they have, depending on the court, they have 90 to 120 days to serve you with a copy of the complaint and the summons. Let's say they don't do that. The court can dismiss the case, so they can dismiss it without prejudice. If the case is dismissed without prejudice, that means it can be refiled again at a later date. There may be a time where, for whatever reason, sometimes someone doesn't show up to a hearing or something's not filed appropriately. The court can dismiss a case. And again, often it's dismissed without prejudice. And that's why if you come to a settlement with your creditors, you're being sued and you've come to some agreement and the case is going to be dismissed. Even if it just seems like you're just being a little paranoid, make sure that in the language of the settlement that the case is dismissed with prejudice, meaning it can never be filed again, and then it's done. So in answer to that question, it could, if it's dismissed without prejudice, they could come again. And the thing to understand and to know is that even if it does get dismissed, the statute of limitations, I'm tripping all over myself. It's as if that lawsuit was never filed if it gets dismissed without prejudice. And so you need to go back and look at the statute of limitations because all the time that case was pending counts towards the statute and it may have expired if they let it get dismissed. So, all right. Then there was one dealing with bankruptcy. This person asked, can a vehicle loan go away when filing for bankruptcy? In general, here's the rule. If you're filing for bankruptcy, the debts are broken into different categories, secured versus unsecured. So secured debts like a car loan that has collateral, has the property, the vehicle, and the loan are tied together. Whereas the unsecured debt like credit cards, medical bills, things like that, they're different. Now, secured debts like the car, if you want to keep it, you got to pay it. That's the deal. There's no free car in bankruptcy. I've had a lot of people misunderstand that, over the years. So we try to make that extremely clear with every bankruptcy client we have. If you want to keep your car, you got to keep making the payments on it. However, I have had clients that come in, the car is, they have other cars, the payment's too high or whatever. You can surrender a car through the bankruptcy, and then you don't owe any more money on it. But if you want to keep the car, you got to keep paying it. If you want to keep your house, you got to keep paying it. Chapter 7 bankruptcy gets rid of things like credit cards, medical bills, personal loans. Unsecured type debts typically go away. All right. And then this last one is really gets into the nuts and bolts of things when it comes to debt settlement. This person says, what's the best way to actually pay them? I wouldn't feel comfortable writing a check out of my account or giving them my credit card information. I get this. And a lot of it, I should tell you this. If you're dealing with a law firm, like a debt collection law firm, or a legit collection agency, usually they are insured by the ACA, which is like the American Creditors Association or something like that. If you're dealing with, and particularly if you're dealing with a law firm, even though you may be like, you know what, I hate their guts, they're regulated. They're highly regulated. The debt collection industry is highly regulated. That's why they have the FDCPA and the FCRA and all these laws. And if they're a lawyer, they actually are governed by the state bar as well. And so if they were to accept payment and they're just screwing you over, the consequences would be huge. And I can tell you, I've been doing this almost 20 years. I have never seen, particularly a law firm, take a payment and then act like there was no settlement or lose the payment, that kind of thing. I mean, that being said, you want to keep receipts of everything. But if the agreement, if you've negotiated agreement and it's in writing, you've got an email, you've got something that verifies what it is, I don't ever have a problem referring my client to a law firm's webpage where they have a portal where they can make an online payment with their debit card. I mean, not only that, you have the protections from your own bank if there's something fraudulent that happened, but I haven't seen that be a big issue. Now, if the statute of limitations has expired and you've got some fly-by-night company contacting you, they won't verify, they won't provide anything in writing as far as the settlement goes, then I wouldn't give them your banking information. But the only other way to really do it is, I have seen people who go out and get, you can get like those prepaid Visa cards that actually have like a number on them. I've seen people use those if they're paying online, or you could go and get some type of a cashier's check if you were going to send it in. Sometimes they require a cashier's check or some kind of money order or something like that, where the funds are verified. So that would be the way to take a look at it. So, all right, let's see here. See what James Norman has to say. How long does the arbitration process typically take in Arizona? And is it binding if the credit card company wins or if you win? Now, because you specifically said Arizona, I'm going to bring in the two different types of arbitration. Arizona has a process that's done through the court system called compulsory arbitration. This is just to make things as more confusing than it needs to be. So there's a difference between compulsory arbitration and what we call private arbitration. Private arbitration, I have the tutorials, which are linked up in the comments section there that I do, that talk about filing a motion to compel private arbitration. That private arbitration is different from Arizona's compulsory arbitration. Compulsory arbitration it's only in the superior court. So anything over $10,000 as far as the dispute, if there's a dispute more than $10,000. And in Maricopa County, where I work for the most part, where Phoenix is, anything under $50,000 in dispute has to go through this compulsory arbitration process. And what it is, it's essentially where they assign an attorney. They just randomly assign an attorney. This is like jury duty for lawyers. They assign an attorney to act as the arbitrator, or to act as kind of like the judge in the case. And then you have this arbitration hearing. This usually happens about 7 to 10 months in the process. And you literally have a hearing. I say it's like an informal trial around a conference room table where the creditor, the plaintiff comes in and puts on their case, you put on your case, and then the arbitrator rules. There's a winner and a loser. It's not like mediation. Mediation is where they try to negotiate a settlement. Compulsory arbitration in Arizona is if your case is in the superior court, over $10,000, under 50, they'll have you go through this process. Interestingly, it's not binding. Compulsory arbitration is not binding. And if either party doesn't like the result, they can just say, hey, judge, go ahead and set a trial date. So I guess it resolves a lot of cases. And it does. I often see, particularly with debt buyers, if they lose at that stage, they'll either settle for much less, or sometimes they don't even ask for the trial date and it just becomes final at that point. So now private arbitration is different. Private arbitration is AAA, American Arbitration Association. JAMS is the other one that the companies use. This is where these are outside private companies. And this process can be fairly abbreviated. Sometimes you could choose to have it done through what's called documents only, where essentially you're just submitting documents. It's kind of like a summary judgment type proceeding. That can happen pretty quickly. You're probably looking at 2 to 3 or 4 months, which is quick in the court. The courts are very slow, particularly with civil matters. In Maricopa County in Arizona, civil cases from the average date or time frame from complaint till you actually get to trial is almost 2 years. It takes a long time to get to a trial type setting. So, but private arbitration is quicker, 2 to 4 months. If you want an in-person hearing, it can take another 3-4 months on top of that. And it also depends on if there's discovery or if discovery's been limited, that kind of thing. So, hopefully that's helpful. All right, let's see. Kent says, what does toll mean with regards to the statute of limitations? How is toll determined? So if the statute of limitations is tolled, what it means is essentially there's been a big pause put on the timeline that's ticking. So for instance, in Arizona, the statute of limitations on a credit card is 6 years. 6 years from the time that the account goes into default. They then have 6 years to file a lawsuit. So the account goes into default, that clock starts ticking, going along to 6 years. And then if you do something, there's certain acts that will toll the statute of limitations. It'll pause it. So for example, a good one is if you file for bankruptcy. Let's say you file for bankruptcy and then it gets dismissed. There's an argument that the creditor has that from the time you filed bankruptcy until it was dismissed, that was paused, and that time does not count against the statute of limitations. So that's what you need to think about, is it's just it's essentially paused there. All right, see what Rye has to say. PR, assuming that's portfolio recovery, filed lawsuit against me, $14,000. Filed an answer, but 20 days, no court date yet. What to expect? What is the best recommended settlement amount? I have multiple credit card accounts. So, all right, let's see here, because I saw there's a couple other questions you had. Statute of limitation expiring in 2023, June on all credit cards. I can't afford to settle with debt buyers. What's your recommended on Chapter 7, wait or see? So in regards to your first question, so it sounds like you said 4-year statute, so it sounds like you're not in Arizona. I can tell you, so in Arizona, if they sue you, you file the answer, it wouldn't be surprising at all that there's no court date. In many states, I mean, like in Arizona, like I said, to get a trial date in the Superior Court, I mean, that could take 18 months. In the justice courts in Arizona, that could take 10 months. So that's not surprising to me that there's no court date. But I know there are some places where they filed a lawsuit and they set a court date 30 to 60 days out. When in doubt, just call a court. Talk to the clerk. They can't give you legal advice, but they can definitely tell you what the process is and tell you, hey, that we're going to be sending something out, or no, there is a date set. You didn't get it. Here's what it is. So that's what I would recommend, is if you're not sure, call the clerk of the court. And then, like I said before, it's always good to maybe do a consultation with an attorney who does this type of thing. So, all right, let's see here. Candace is asking, can you negotiate an existing credit card interest rate? Wouldn't they want to negotiate rather than get nothing in a future bankruptcy? Everything can be negotiated. I always say that. A lot of times, though, when you're dealing with particularly large credit card companies, they have policies in place that it doesn't matter if it makes sense. It doesn't matter if it's to their financial best interest. They follow those policies. I have a brother-in-law who works for one of the big car manufacturers, and he taught me that lesson a long time ago because he was telling me some policy that this company had. And I said, that doesn't make any sense. And he said, but that's the policy. And he's like, we can't deviate from the policy. So it depends on what their policy is on that. What I have seen, existing credit cards, if you fall behind on it, if you're 2 or 3 months behind, where they do negotiate is they may say, hey, we'll do 0% interest for the next 6 months to help you get kind of back on track. And they'll do something like that to help bring it current. I talked about this, I think, last week on the live stream. The thought of, or the threat, I should say, of bankruptcy is not super effective because it's really kind of baked into the cake already. They know, both credit card companies and debt collectors, and they know a certain percentage of the people they try to collect on are going to file for bankruptcy. And so I think it's already kind of worked into their system that they know that that's going to happen with a certain number of accounts. And it does have, there's the cry wolf effect that I think a lot of people say it, And it's understandable why they kind of try to use that, but they hear it all day long. And so they may say, well, just file then. So it's a powerful tool because it absolutely will. They'll get zero, but I think they just kind of move on from it. So, all right, Alex, and I saw her in the chat there. We stole your thunder with the previous question. So can you motion for private arbitration before the compulsory arbitration hearing? Yes. I mean, my recommendation is you move for private arbitration quickly. This happened maybe even in response to the complaint rather than waiting. Once there's a hearing set, and I can tell you this, so with compulsory arbitration in Arizona, if a hearing gets set and you want to do something like this, you can always reach out to the arbitrator and see if they'll continue it or push it off. Now, they do have some time limits where it has to be completed by, but I can tell you with compulsory arbitration, like I said, it is the jury duty equivalent for lawyers. They're not really paid. I think they get $75, and that's only if you appeal. And they have to put quite a bit of effort into it. And not only that, it's kind of a luck of the draw. I've had arbitrators that are like probate lawyers, wills and trust lawyers that have never been into a courtroom in their life, and so they come in there like, I don't even know what I'm doing here. It'd be like me going into their practice area. I don't. As weird as it is, I took wills and trusts in law school 20 years ago, and I've never drafted a will in my career. So it's not like we all know how to do all these things interchangeably. It's something where my point being that the arbitrator would like to probably not do the arbitration hearing as well. And so if there's a reason for you to do it, for them to get out of it, they may be willing to work with you on that. So, all right, let's see here. Oh, you know what? I didn't answer Candace's question because I think you asked about, it was actually Rye's question. If you can't afford to settle, would I recommend filing Chapter 7? If you can't afford to settle, I mean, with debt buyers, you can kind of wait and see. The problem is sometimes they'll sit around until the very end of the statute of limitations. And if you know that if they start suing you, you're going to file for bankruptcy, often I recommend people just, hey, do the Chapter 7. You'll recover from that in about 2 years, be able to move forward. If it's just sitting out there for, it could be 4, 6, 7 years on your credit will recover much more quickly than that. So, all right, let's see here. My case has been cold for a good 2 months since filing my answer. I'm buying time. Should I attempt to negotiate now? If I should get a summary judgment, will I still be able to negotiate? Now's a good time to negotiate if you're going to try to work out a settlement. You're in this disclosure/discovery phase of the lawsuit. And usually this is when the best settlements that I see during the litigation process happen. But at the same point, if you wait until summary judgment gets granted, then all of a sudden there's a lot of pressure. You're on the clock to get some type of response done. And they may interpret that as having a bit more leverage, the creditor will. So I usually recommend if your goal and your game plan is to get this thing settled, I would submit an offer now. Not only that, because if they have to draft a summary judgment motion, they may feel like, hey, we've had to put more time, more money into all this. And so they may want a higher settlement for them. So, all right, let's see here. James is asking about one of my tutorials. Will my course on either arbitration or Capital One essentially guide me through when and how to file answers and motions? How much is it? Go take a look at it, like the one on how to compel private arbitration. I mean, there's a template in there. They're step-by-step tutorials where I literally am walking you through how to draft it. Same thing with the Capital One. We charge, I think they're $95 right now. So go take a look at that. And I think I got your second part. File bankruptcy before the debt buyer sue me or wait to see. If bankruptcy is inevitable, it's kind of like the debt settlement question. I have people who will say, hey, I've got a creditor that's suing me, is being all aggressive. Should I fight them or should I file bankruptcy? And I always say, if that's the only problem you have, and if we fight it and we win it and then it's out of your hair and then you can move on, great, let's do that. But if it's one of these things where you fight one of them and then 3 more are going to file lawsuits in 2 months from now, and then you beat them, and then, if it's something where we're kind of just tip of the iceberg, then I'd say you maybe ought to consider bankruptcy. I would recommend doing a bankruptcy consultation just to see exactly what the process is and see if it's a good option for you. So, all right, let's see here. We'll do Jack. And I'm going to have to, unfortunately, cut it a little bit short. My daughters have a dance recital tonight, and I better get there or I'm going to get in trouble. Jack says, I had my case dismissed with prejudice in August. I completed the FTC identity theft paperwork. What is my next step? Well, if it's dismissed with prejudice, that means it's done. Again, like we talked about at the beginning, they're not going to be able to come back. The next thing you need to do, I would pull a copy of your credit report. Sometimes it takes 1 or 2 cycles of reporting, every 30 days, but see if they've updated that so that they zeroed it out, and see if you can get that squared away. So that's my next step would be to do that. Make sure that they're updating the credit report to show that you're no longer liable on it. And hopefully that'll get that completely out of your hair once and for all. So, all right. I think we'll end it there. Like I said, I got to get there so that my girls don't get mad at me. But hey, thanks for everybody for tuning in tonight. And next week, I probably won't have a live stream. It'll be Thanksgiving, and hopefully you're not doing this on Thanksgiving. But I'll have some videos that I'll have there in its place. But if there are questions, always put them in the comments. Like I said, I do read through them. I try to answer them, and we can all take it from there. So everybody have a good evening, and we'll talk to you